Harrington here, guys. Yep, we're doing this. All right, now, I didn't start out with the intention of doing a 3-part series on estate planning because I'm a little worried that at some point I might leak into stuff that you guys don't care about. So I'm keenly aware of that danger, and I'm going to avoid it. But let's face it, you guys have assets, so most of the stuff you do care about. And really what I'm going to try and get into here today, I'm going to call this the advanced estate planning. I'm going to get into how you can balance what is the estate planning aspect of it. In other words, trying to streamline who gets what and how things are going to pass, the succession aspect of it, along with the asset protection aspect of it. So we're going to talk about that today, and that's probably stuff that you guys will care about. And the moment I feel like I'm getting into territory where you may not be interested, well, I'll just tickle it and then run away. Here we go. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1. Okay, let's, I'm going to have to do a little bit of a recap, but I'm not going to go all the way back into doing nothing and having just a will. If you need to hear that part, go to episode 43 to get that recap. But let's just pick up where we left off at the end of episode 44, which is having your basic components to a basic estate planning plan in place, which are your pour-over will that works in concert with your family trust or your estate planning trust. It's like your principal trust. Those two, that combination, that's like, the basic setup. Again, just briefly, why do we call it a pour-over will? Well, it's because it has this clause in it that says, look, when I die, anything that belongs to me, my personal belongings that aren't titled already under my trust, those things just pour over automatically into my estate planning trust to be then governed by the stipulations, the clauses of my estate planning trust. That's one of the main functions of a pour-over will. And then, of course, it has the other stuff that's non-financial in nature, like, who's going to make your decisions for you when you can, regarding your health care. It's going to name your personal representative. It's going to do some other things, but it's not going to be your main asset planning vehicle. It's just going to have that function of pouring over into your main trust. All right, just quickly, and by the way of vocabulary, this is going to be a living trust because you're going to make it during your lifetime. You're most likely going to make your trust a revocable trust, which means that you can modify it at any time or even terminate it if you wish. There does exist such a thing as an irrevocable or irrevocable, however you want to say it, trust, and the concept is this. Well, first of all, let me break it into 2 parts. It is common that your revocable trust will become irrevocable upon your death. That's typically how that works. But then it is possible to have your trust be irrevocable right from the outset, right from the inception. Now, why would you do that? Well, that gives you a much greater asset protection mechanism. And why would that be, you may ask? Well, go back to my earlier asset protection videos, but just, as a recap, remember that as a trustee, if you control the assets, then those assets are deemed to be yours. And in many cases, we want to separate assets from your estate, and that's the way you do it. You don't act as your own trustee, and you make it irrevocable. And with that combination, then for legal purposes, the things that belong to the trust do not belong to you personally, and so they're not exposed to your personal creditors. Okay, but I know that's all review for you guys at this point, so let's move on. Part 2. Let's get into adding tiers. Now, I did touch on this in the last episode, but I want to go a little deeper and tell you what I mean by that. Tiers, not, tiers because somebody died. I'm talking about levels, tiers in that sense. You're probably going to end up with a pyramid. Most of my clients do. So at the top of the pyramid, you're going to have your pour-over will and your family trust. That's going to be your primary vehicle that controls everything. And you're going to want to do this vertically to the extent that you can because you want everything to flow up in streamlined fashion. Both the money will likely flow up, and we'll get into that. We'll break it down. And then, ideally what you want is that your entire enterprise is controlled by one document, the trust agreement for your estate planning trust. And so you want to do it vertically. You want, what do I mean by that? I want, level number 1, your primary trust, to be the owner of the things in level number 2. and I want the things in level number 2 to be the owners of the things in level number 3, and so on and so forth. And if you do it that way, you can have it so that one document essentially will control your entire estate. All right, so what goes below your main estate planning trust? Companies. I would put your business entities at level number 2. So your LLCs, for example, or your corporations, or your partnerships, whatever. And then what you do is you make, so we use different terminology for each one of those types of entities, but for an LLC, the member of the LLC will be your estate planning trust. If it's a corporation, then you're going to have all the shares owned by your estate planning trust. Partnership, same thing. The general partner will be your estate planning trust. Now, for accounting purposes, you'll have a conversation with your accountant, not with me probably, as to what is going to be the most efficient way to do your tax returns, because you may very well end up doing your tax returns at that second level. So you can make those entities what's called a C Corp. That's one option. And the entities themselves will file their own returns, and they'll be separate, and there may be some advantages to doing it that way. Conversely, you could allow the income to pass through that second level up into your estate planning trust, and you could do your filings at that level. So that's a strategic conversation that you're going to have with your accountant. It's very personal, but just be aware that you have those options. Now, let's move down to the third tier. What goes below your business entities? Well, your investment properties, for example. My suggestion, what I think it works out great, is to use land trusts. You put your investment properties in land trusts, and those land trusts are then owned by your LLC, more than likely. So all the rents, they pass through those land trusts, and they go to your LLC. That's where you're going to do your accounting. That's where you're going to have your bank account. It's going to be the name of the LLC. And so, you use that LLC for all the financial purposes. Closing title companies, they understand LLCs better than they do trust very often. Bankers usually understand LLCs better than they do trust. And so there's some very practical reasons for setting it up that way. Let me just touch on something real quick. A lot of you real estate investors are in the habit of creating a different LLC for each and every property that you have. And there's nothing wrong with that. You can do it that way. And if you have big properties, if every one of your real estate holdings is something big, a mall or whatever, a commercial building, then that's probably a good way to do it. I wouldn't say not to do it that way. But if we're talking about, just some small rental units, or maybe some fix and flips that will be in and out of your portfolio before too long, well, it is maybe a little overkill to set up a separate LLC for each and every one of those things. Maybe just do a land trust. A land trust, I can prepare for you a template that you can really just fill in the name. You're probably going to use the address of the property as the name of the land trust. So, I'm at 311 Golf Road. So it'll be 311 Golf Road Land Trust, and so on and so forth. You'll use a separate land trust for each and every one of these smaller properties. If you do it that way, and I don't want to digress too much, but if you do it that way, then you're going to have wonderful asset protection, because each one of your properties is going to be in a separate entity, a separate land trust. And so that means that if something affects one property, it's not going to affect any of the others. It's certainly not going to go upstream and affect your business entity at the second level. And it's very far from affecting you personally getting to your top tier, which is your estate planning trust. So it's wonderful asset protection. You do, of course, get the same asset protection aspect by creating separate LLCs for your real estate holdings. As you do with a land trust, it's more of a hassle, right? For an LLC, you're going to have to register it. It's a small charge, but you have to do that for each and every one, and then you have to do those annual renewals. Again, it's not a big charge, but you have to do it. And if you do miss the deadline to renew, all right, well, now we are starting to talk about some money, because it's at least $400 here in Florida as a penalty for missing that deadline, and it can go up to $600 depending upon just how late you are at doing your renewal. So, by the time you start multiplying that by multiple LLCs, okay, now it actually, I might get your attention. So that's my recommendation to you. If you're going to have real estate holdings, I would strongly encourage you to look into the land trust. Go check out some of my earlier videos where I go into how a land trust works. I love those things. They're very efficient. They're super confident. They're confidential. That's another thing about the LLC is that anybody can go on to sunbiz.org and it's quite transparent, right? There's no confidentiality at all. We're going to see who the owners are. We're going to see who the managers are. We're going to know what their addresses are. It's very out there. So that's another great thing about the land trust. And it's also very flexible because it doesn't get recorded anywhere. It doesn't get registered anywhere. It's just a piece of paper that you can stick in your safe, or I'll keep in my archives. And whenever you need to make any changes, there's no, mailing off amendments to the State Department, nothing like that. You just tell me, I'll make the change, and boom, it's done. So that's for real estate holdings. Well, another thing that comes up is below that second level where you have your business entities. What about company assets, like company cars, company vehicles, for example, or heavy equipment? Those things that have titles, a boat, maybe. Well, there can be some good reasons for separating those out as well. You can, of course, and it is commonly done, that the company is the owner of all those assets, and you just hope for the best. But depending upon the type of company, if it's a construction or transportation company and you have lots of drivers out on the road, it's just a matter of time before there's going to be an accident. If you're in construction, it's just a matter of time before your crane or your loader or your excavator does some damage to somebody's property. That is going to happen. So why expose all the company's assets to something that happened with regard to one particular piece of equipment? So in that scenario, let's do this instead. You're going to create a sub entity, something below that LLC, like maybe a sub LLC. That probably would make the most sense. Now, depending upon just how many vehicles you have or how expensive each one was, then you may want to have, say 3 vehicles in one of those sub LLCs. And then maybe you have another sub LLC for your heavy equipment, which is probably worth lots of money. That is going to give you some nice asset protection that you would not otherwise have. And it's also going to open up the possibilities. Again, this is a conversation you're going to have with your accountant, probably not with me, but you could have this sub LLC leasing vehicles to your main company. And there can be some tax benefits to doing it that way. Part 3. Okay, here's where I'm getting a little bit far afield, so I'm going to be careful. I'm just going to tickle these topics and then bounce. But let's touch on it, just so you know that these things, these mechanisms, these vehicles are out there. Let's deal with special needs and Medicare/Medicaid benefits planning together as one topic. They're 2 different things, but let's kind of try and treat them together because the techniques are similar. Starting with special needs. We're actually dealing with one of these cases right now. So listen, if there's a special need beneficiary, there are benefits available for this individual. And you may want to be careful about how you structure that individual's assets, because if they show a lot of assets, then they're not going to be eligible for the benefits. And the same thing for the elderly, right? When you get to the age where you can start receiving some governmental benefits based on age, again, you don't want to show too many assets because then those aren't going to be available to you. Now, before you think that this is underhanded, it's not actually my expertise. This elder law is not really my area of practice, but there's nothing underhanded here. There are special trusts that you can set up for the situation, or special clauses that you can include for the situation that are perfectly legal. And just a smart way of doing things. Again, without going too far into it, just be aware of this. So, for example, if you have somebody with special needs, maybe they were in a terrible accident or something, or an operation went wrong, and there was a recovery, so they have some personal injury funds. Well, if the funds come from the individual with the special needs, then there's going to need to be a payback clause. So when that person passes away, then whatever assets are left over will have to, some portion of that will have to be used to pay back the benefits that they received during their lifetime. So you see what I mean? It's all in the up and up. By contrast, and then I'll move on. If the funds come from a third party, like a parent or a loved one leaves funds for the person with the special needs, then there is no payback clause. All right, let's move on to something else here. You recall that I've told you before that if we're doing estate planning here in the United States, it's very difficult, maybe impossible, to do anything with your foreign assets. If you have homes or whatever in a different country, I don't know the rules of every single country, the laws of every country, but it is very common that you're not allowed to disinherit your kids, for example. They have their statute set up, and when somebody passes away, the family goes to the notario, and then, the notario says this is the way it has to be, and you don't have a lot of control over it. Okay, well, that is by and large true, and I'm not really going to back down from that, but I do want to mention this. It is possible that on your second level, remember, you got your main trust at the top, and then it's your second level, you have business entities. Well, maybe at that same level, or third level, doesn't really matter, you could have a foreign trust. So the foreign trust can be owned by your estate planning trust. You can do that, and there's some wonderful asset protection benefits available to you there. Go back to my video on offshore asset protection. And it might, I just say might, because it's going to depend upon the country. This is going to be a very individual sort of analysis, but it might just be possible for you to put some of your foreign assets into this foreign entity, probably a trust, fideicomiso, if you're in a Spanish-speaking jurisdiction. It may be possible for you to include some of those foreign assets to some extent along with your overall U.S. estate planning. Don't hold me to that, but just be aware that mechanism does exist. And that's really about as far as I'm going to go here. I mean, let me just tell you that there are lots of other techniques that you can use. There's like intentionally defective trust that you can set up for tax purposes. There's something called a Q-tip trust. There's something called a crummy trust. They have great names in this area of practice, by the way. You can have your trust decanted. There are occasions when you'll do that. I know I'm just throwing stuff out there now, but I guess the point is this. Whatever your specific circumstances are, whatever your particular concern is, or the goal you're trying to accomplish, there's probably a trust or language that you can include in your existing trust that will address your particular circumstances. So we don't have time to touch on all of that, but I want you to know those things are out there, and it's all part of advanced estate planning, whether your purpose is to minimize tax, be more tax efficient, or take care of a loved one who is not able to take care of themselves, or just about any other scenario you can think up. Something has been created to address that situation. And there you have it, guys. All right, next week, I promise you, we are going to dive right back into the hardcore business and or real estate investment world, and we're going to stay firmly there. You know what to do with the likes and the comments and stuff. Do the honorable thing, and I'll talk to you then.